in addition to having rules prohibiting certain kinds of online conduct, St. Paul's has systems in place to monitor compliance with student compliance with these rules and to investigate violations, don't they? They have ways to monitor compliance to see that people are not violating those rules?
No.
They do not?
No, not in the broadest sense.
In some sense, do they have any way to deal with violations of the rules?
We have processes in place within the Dean of Students' office to deal with reported behaviors.
There's a section in the handbook, and I believe it's in the section that on page 113. Do you have that? The section that Attorney Maloney had given you earlier?
Yes.
Okay. So, should be on page 113. Does the court have a copy of that?
Well, it's an exhibit.
Okay, but would you like one so you can see?
If you want me to, that's fine. Thank you.
So let's see, it's the second page of it, section on privacy. And if you see that section on privacy?
Yes.
Okay. It says St. Paul's School reserves the right to monitor and track all behaviors and interactions that take place online or through the use of technology on our property or at our events.
Correct.
Now, do you agree with me that that includes behaviors and interactions that take place within the St. Paul School intranet? Or
Correct.
Does it only apply to the ones on the internet? Does it cover the ones that may take place within the intranet?
It specifically talks about the St. Paul's intranet.
Okay, so it would cover those as well. Would you agree with me that given the size of St. Paul's School intranet, which I believe you said could have over 1,000 devices on it, and the diversity and sheer number of people using it, it's necessary for the school to have clear rules regarding acceptable behavior when using the intranet as well as the internet?
Correct.
Okay, that's all I have, Your Honor.
Mr. Morin, how long have you worked in the field of internet technology or technology?
30 years.
Fair to say that the internet has an infinite number of users?
Yes.
So approximating based on what you testified on cross, St. Paul's may have the intranet.
Counsel, I think I can take it judicial notice that the number is not infinite. It may be high, but it can't be infinite.
Judge, I would argue that it is infinite because it continues to grow daily.
Yes, that's a high number, but it's not
It is.
infinite.
That's
It's
fine.
not infinite.
That's fine. Fair to say that even based on all the information and all the users of the St. Paul's intranet, that quantity of users is but a drop in the bucket of the total number of users of the internet.
Safe to say yes.
There would be approximately, I'm guessing, under 2,000 users on the St. Paul's intranet system.
Yes.
And you could tell me the name of every one of those users if you had to.
I could not tell you guessed.
But you could tell me the name of every registered student or user account that you have.
Every user logged into our network, yes.
The intranet is a closed universe system.
Well, the internet has access to the internet, so
Correct, but the intranet, as far as email is concerned, student computer to student computer on campus, is closed universe.
on SBSnet, yes.
You were contacted after trial on this matter. I think that came up on direct.
Yes.
And you indicated on your cross, and I believe on direct as well, that if you had reviewed the logs, you may have been able to say how these messages were sent. Is that accurate?
Yes.
Fair to say that by the time the Concord Police Department contacted you, those logs had been overwritten and that information was no longer available?
Correct.
How was the cell phone service at St. Paul's?
If
I
you're-
won't tell your boss.
If you're a Verizon user, it's very good. AT&T is decent.
And is Wi-Fi available across campus?
Yes.
I have nothing further, Judge. Thank you.
Thank you.
Mr. Morin.
Anything further, Mr.
She
Chief?
did bring up one thing I wanted to clarify. With regard to your ability using special IT tools that could track messages and the pathway that they traveled. I believe you testified that it's continuously overwritten and that the time is indeterminate before it gets overwritten, but it could be as much as a week, right?
Correct.
So that would be a built-in limitation on all email traffic, sps.edu, that after a week time, forget about tracking the pathway that it took, right?
Correct. Logs overwrite.
And do you know what, I forgot, was you're an IT specialist, you studied IT?
Yes.
Do you know how many and you have like over 2,000 connections, or approximately 2,000, now she says under 2,000 connections? How many pairs would that, possible combination of pairs would that be? If you have 2,000 and you're talking about how many emails can go between two people? How many different?
I couldn't do the math on that. It's an exponential formula there.
Is it possible that okay, it's an exponential formula, it's a large number. That's all I have, thank you.
If there's nothing further, you may step down.
Mr. Morin, I would release this witness if the state is comfortable doing so. That's fine with me. Thank you very much.
Yes, witness is excused.
And apparently we'll just not get Attorney Rancourt. Attorney Rancourt, you can have a seat. With the court's permission, I would remind you that you're still under oath. And I believe you are aware we have an agreement for sequestration. Did you discuss the content of this morning's testimony with anybody during our break?
No, a reporter did ask me just to clarify what my role had been, whether she should call me co-counsel or local counsel, and I said it would be more accurate to call me local counsel.
But you didn't discuss the contents of testimony that took place?
No.
Sorry, Judge, just 1 second to shift gears.
Sure.
Judge, I've made myself a note that says that I need to move to strike the ID on a couple of exhibits that I had not done earlier. So I would move to strike the ID on, if the clerk could help me, I believe it was 10A and 10B. So I'd move to strike the ID. I believe the state is in agreement with that being an exhibit.
Granted.
Thank you. Attorney Rancourt, I want to return to two housekeeping matters just to clean up what we had discussed this morning. The first, you stated that you had been provided with for lack of a better word, captures of various individuals' email accounts.
Correct.
How were you able to access the information in those accounts, and was it easy or difficult to do?
It was somewhat complicated to do. When we had first tried to open them by just, clicking on them to open them, they would open in our own email boxes. So, for instance, like if I went to look at an email in Ms. Prout's email, it would open through my personal Outlook on my computer. So then it would look like the email was Jaye Rancourt would be the heading, and then the substance of the email would look as if it came out of my email box. So we said, well, that's clearly not going to work because you're not looking at it in its native format. So we had to download a program. We had to buy a program that we then could install on our computers, and that allowed us to access all the emails in their original format, so we could see who they were to and from and the original dates and that data.
How long did it take to go through those email inboxes?
Oh, many hours. I mean, days it took. My associate did the bulk of that work and looked through all those email accounts and then would call what she deemed to be appropriate or wanted to bring to my attention.
In investigating the computer charge, which we spoke about this morning, did you, actually, Judge, may I approach the witness?
Yes.
1M, which is Jaye's showing you a document that's been marked for ID as 1M. If you've had a chance to familiarize yourself, let me know.
Okay.
Are you aware of what that is?
Yes.
Can you tell me what it is?
It's an affidavit that I prepared after my conversations with Mr. Morin.
Okay, and Mr. Morin being the St. Paul School IT guy.
Correct.
And as part of your investigation into the computer charge, you learned that messages sent from a cell phone could be sent over the internet as opposed to the intranet. Is that true?
Yes, he had told us in our meeting that computer to computer, I believe I'm paraphrasing it correctly, computer to computer would likely stay on the intranet system, but if it was connected through some other device, like a cell phone, you were accessing your St. Paul's email account through the use of a cell phone, that obviously would go outside of the local server.
And follow up to that, did you speak to Owen about whether or not he had a smartphone on campus?
I did.
Are you aware of if he had a smartphone on campus?
He did not.
Thank you.
And I believe there was other testimony about that too. I think Owen McIntyre had stated to the police originally that he did not believe Owen had a phone like that on campus as well.
So I'm going to return to the issue of jury instructions. I think it's fair to say that you were not required to be present at trial.
That's correct.
Can you tell me if you, and I think you stated earlier that you were present for various points during trial as an observer.
I was present as an observer until a day when I was called in.
How much of the trial do you think you saw?
I think it was about half.
And at what point did you...
Well, maybe, let me rephrase that. It was probably about half of the state's case, because I did see all of Owen's case, so all of Owen's testimony. So if you figure that out, maybe it's a little bit more than half, but about half of the state's case.
And at the time you were excused from trial, did you speak with Attorney Carney about whether or not you would be required to assist with jury instructions?
We had no conversations about jury instructions when I was recused from trial, or excused from trial.
Were you asked to provide information pre-trial on jury instructions that may be appropriate in this case?
No.
Were you asked to review the standard instructions that the court would typically give in this case?
When Your Honor issued his draft instructions that he was proposing to give to the jury, they did ask me to review them at that time.
Where were you when they asked you to review them?
We were outside the courtroom in the hallway, and attorneys, they had some kind of chambers conference, and come out of the chambers conference, and Attorney Zagangori had them in his hand, and he said, "I'd like for you to take a look at these." And I said, okay, and held my hand out to get them. And he said, "I only have one copy, I can't give them to you now, but if you're willing to take a look at them, I'll send them to you."
Were you part of the chambers conference where those instructions were handed to you?
No.
Were they aware that you were in the courthouse at that point?
By that point in trial, I was coming regularly because I had learned of some problems. And so I made it a point by that point on in the trial to be there. But again, as an observer, they had not asked me to be there.
I'm going to take a detour for a second. You indicated that you had learned of some problems.
Yes.
Can you tell me at what point you learned of problems and what you perceived those problems to be?
I learned of two problems, one that was brought to my attention and one I would say I'd stumbled upon. The morning of, I don't remember which day of trial, but I remember it was the day that the state's DNA experts were testifying. I had received a call in my office that morning from, I believe it was Attorney Zagangori, and the message was, I didn't talk to him, but the message was, "Owen wants you to come to the courthouse to meet him at noon if you're available." And so I had come to court that day to respond to that request.
So when you were at the courthouse that day, did you meet with Owen?
Yes, and so I was at the courthouse, which is how I stumbled into the other problem. So I got to the courthouse a little before the lunch break. The state's serologist was on the witness stand. The courtroom was packed, so I couldn't come in to see his testimony. I was waiting out in the hallway when Attorney Carney and the defense DNA expert came out of the courtroom. They went into a room outside the courthouse, of course, outside the courtroom. Attorney Carney said I could come in. I went in with them. I was present for an incredibly unsettling conversation between the two of them, which was the point at which I decided I would be present for the remainder of the trial.
Conversation.
Sorry, would you repeat? I didn't understand the last.
Sorry, I said I was then present for a conversation between Attorney Carney and their DNA expert, which was very unsettling, and I decided at that point that I would be present for the rest of the trial. And then after that, so we had that conversation, then there was a lunch break at some point after that when I didn't even actually have a chance to talk to Owen at that time, but I learned why I was asked to come to the courthouse. And then later that afternoon, after trial broke that day, I had a private conversation with Owen at that point.
Okay, I'm going to go back to the uncomfortable conversation that took place in the anteroom. You said that this was during the testimony of or at the conclusion of the testimony of the state's serologist?
I understood, I wasn't present in the courtroom, but I understood it was a break that Your Honor had permitted after the serologist had testified and before he was cross-examined.
And to be clear, there were two state experts who testified on the DNA piece, the serologist and then the lab analyst as well.
Correct.
The DNA folks, okay.
Correct.
And this was specifically the serologist?
Correct.
Okay. Can you tell me the nature of the conversation and what raised your concerns in the anteroom?
So I was in the room with Attorney Carney and the defense DNA expert, who I had never met before. I had never seen any of the defense depositions. I had never met any of the defense experts. I had never met any of the state's experts. I wasn't present for any of the state's expert depositions, nor had I ever been provided transcripts of them. So I had not been familiar with that. So I'm in the room, and the defense DNA expert is explaining things to Attorney Carney about topics to cover in cross, and Attorney Carney was getting frustrated that he did not understand what the DNA expert was saying. They had some back and forth, at which point the defense expert said, well, usually I meet with someone before trial and I'm not trying to explain it to them in 5 minutes. At which point I became incredibly alarmed that it became apparent to me they had not met on a previous occasion.
So your understanding and your takeaway from that conversation was that Attorney Carney had not met with the defense DNA expert before trial?
Yes,
And they were prepared to put this witness on the witness stand?
they were discussing it.
Did that witness take the witness stand?
No.
And did Attorney Carney have anything further to do with the DNA?
No, Attorney Carney did not cross the serologist expert. And then in later conversations with that same defense DNA expert, Attorney Zagangori stepped in and said that he would do it because he did have a better understanding of what the expert was attempting to relay to them.
Are you aware of whether it was the intention all along for Attorney Zagangori to do that cross-examination?
I'm aware that that was not the plan because Attorney Zagangori and I and the DNA expert sat in the room in 10 minutes and drafted what a cross should be.
Do you think that that cross was an effective cross of the DNA expert?
I think that Attorney Zagangori did a pretty stellar job given that he had to step up in about 10 minutes and figure it out.
Is that routinely how you would prepare and present an expert as a defense attorney?
No.
What typically would you do to prepare and present a defense expert at trial?
I would meet with them, possibly on more than one occasion. I would, they probably had been deposed. I don't remember if the state deposed their DNA expert or not, or who was present for it, but typically that would occur. And then you would, if you had questions periodically, talk to them on the telephone, but you certainly would at least meet with them, I would think, face-to-face one time.
So that was what prompted you to be present in the courthouse from there on?
Yeah, I mean, sorry. That was possibly the most terrifying moment of my legal career. I was sitting in that room thinking, I'm going to have to go in that courtroom and interrupt this trial and step in and say, I can't let it go on. And was thinking, how do I do that? So at that point I said to myself, okay, something's not right here, or something's not going well, and I have to be present and try to insert myself as much as I can into the case.
Why did you not talk to the judge at that point?
Because when Attorney Zagangori stepped in and said that he would do it, and then we worked with the DNA expert in the room for a while, and I did feel like Attorney Zagangori had a good handle on the basics and, could handle it so that it wasn't going to be a complete train wreck. And so I felt like it was then not appropriate for me to raise the issue, as I felt like Attorney Zagangori could step in.
Do you wish you had?
I do. Looking back, I absolutely wish I had.
So this gets us to the courthouse on the morning the jury instructions were discussed in a chambers conference in which you were not in attendance.
Yeah, I think it was actually an afternoon chambers conference, if I remember, because I think they had come out of the chambers conference, and I think it was the end of the day.
So Sam mentioned to you in the hallway that he had a copy of the instructions and perhaps would send them to you?
Yes.
Did he tell you when he was going to send them to you?
No, he just said, this is my only copy, so I'll send you a copy.
What time was that? Do you remember roughly? I'm not asking for a specific hour.
Yeah, it was, I believe it was at the end of the day, because I recall leaving the courthouse and going back to my office at that time.
Why did you go back to your office?
I went back to my office to get the instructions and to review it, because at my office I have my statute books, case law, what I would typically have to review in reviewing jury instructions.
How do you typically, in a case for a jury trial, prepare jury instructions? And at what point in the case do you prepare jury instructions?
Typically, before a trial begins, I will draft any instructions special instructions that I would want. I mean, there's your standard instructions that don't really change from case to case too much. But then if you're looking for any special instructions on the charges, on stipulations, on maybe evidence that's coming in for limited purposes or something like that, I might draft my own version, what I would like the judge to give, pre-trial, but then I review the standard instructions and call out from the standard instructions what instructions I think would be appropriate to give. And if there's special instructions, I would then submit those to Your Honor.
So before the time that you were handed these, that Sam indicated he would be sending you the instructions, had you had any conversations with Attorney Carney or his office about jury instructions?
No.
Had you been presented with any draft instructions?
No.
How late were you at your office that night?
I went back to my office and waited in my office for a few hours. And I called Sam a couple times, Attorney Zackingori, a couple times, and asked him if they were coming. And there was something about he wasn't able to get back to the office, or something about not being able to get them to me right away, but that they'd be coming. I ultimately left my office to go home and put my son to bed, which is typically like 8 o'clock that he goes to bed. So I left my office probably around like 7:30 to get home in time.
And at that point, you had not received the instructions?
No.
How did they ultimately come to you?
Later that night, I, on my phone, well, I mean, they were emailed to me, but the only device I had to view them on, unfortunately, was my phone, my iPhone. And so they came as individual JPEG photos of certain pages of jury instructions. There was a page missing. They came to my phone sometime that night, maybe 8:30.
So to be clear, not PDFs, JPEGs.
Correct.
Okay. Judge, may I approach the witness?
Yes.
Showing you a document that's been marked for ID as number 29. Can you take a moment to take a look at the pages of that document? I didn't realize it until just now, but I believe there was some duplicates in there. Let me know when you're ready to discuss that.
Okay.
Can you tell me what that is?
That's a copy of the email where Attorney Zackingori had forwarded the jury instructions to me.
Can you tell me what time that was sent?
8:39 p.m.
And can you read it, please?
Hello, Jay. I am attaching the jury instructions in parentheses in 14 JPEGs. Sorry it is so late. If you have a chance to look at them prior to tomorrow morning, I would appreciate any thoughts you have. Thanks.
Had they instructed you or asked that you, at this point, when you received those, had they instructed you or asked you to be present the following morning for
No.
jury instructions?
No.
And did you receive every page of the jury instructions in that email?
No, I was missing page 13.
How did you review them?
I was literally lying in bed. I got up. I had to enlarge them, try to read them on my phone, and skimmed. I mean, I read through them, but I would call it more of a skimming through them. A couple things struck out to me, and I sent off an email saying, in my very brief review, I don't remember exactly what my words were, and pointed out a couple things. I ended up pointing out a couple things that were wrong because I didn't even have my statute book there to refer to them.
Were you prepared to review them at home?
No, I assumed, when I went home that night, I assumed they weren't coming.
So when you did review them, and based on the text of that email and the tone of that email, did you believe that they were relying on you for a review of those, a final review of the jury instructions?
Absolutely not.
Why not?
Well, I hadn't read discovery upon their instructions not to do so. I had never been present for any discussions with them about what their trial strategy was. I was excused from trial. I hadn't seen half of the state's case. I had no idea what evidence had been introduced those days. If they had come to me and said to me, "We're relying on you for jury instructions," I would have said, "No, you are not, because I cannot do that. I could not be effective in doing that because that would be silly. I don't know the evidence. I don't know if there were stipulations. I don't know if evidence came in for limited purposes. I had no idea because I had not been in the courtroom. So I would have refused to even participate if I knew they were relying on me.
Did you believe that they had already taken the steps and that these were basically a final draft of the instructions?
I assumed that they had submitted whatever they wanted to submit, or at least had discussions about that, reviewed them themselves and identified any problems there may be, and were just looking at me for, third, fourth set of eyes on them.
So you appeared in court the following morning.
Yes.
Was that at anyone's request or just because you showed up?
That was just because I showed up. And as I had said before, I double-checked my billing records on that, because the day before when they had called me in at Owen's request, and I had spoken to Owen that day about that issue, I billed that time because I had been asked to come. The next day, the day the jury instructions were given and the day the Chambers conference occurred, I didn't bill for any of that time, which would have reflected my thought at the time, which was that I was not on the clock, so to speak.
What happened when you arrived in court the next morning?
We arrived at court the next morning. It would have been the morning that the closings were going to happen, and we were again outside the courtroom in the hallway, and Attorney Carney said to me something like, if you have something to add in the Chambers, I want you to come into the Chambers conference with me, feel free to jump in, add whatever you need, something to that nature. And we were going into a Chambers conference to discuss jury instructions. That was my understanding.
At that point, were you handed a copy of final jury instructions?
No, I don't think so.
And had you had any further communication with Attorney Zagangori, Attorney Carney, or anyone else about the jury instructions at that point?
No, there was just the one email the night before that I sent in response to Exhibit 29.
So did you attend that Chambers conference?
I did.
And what was your role in that Chambers conference?
I don't specifically remember, and I don't think it was recorded because I've never received a transcript of it, so I assume that means it was never what there was not a steno there. But I do recall I probably said a couple things. I think there were a couple questions that were raised in Chambers, and maybe I responded to a couple questions or spoke up about a couple things, but I don't remember exactly what the issues were or what it was.
Did you believe you were in charge of that Chambers conference?
Absolutely not.
Would you have been or have agreed to be in charge of that Chambers conference?
No, absolutely not.
When did you learn that you were in charge of that Chambers conference?
The first time anyone ever said I was in charge of that Chambers conference was in a telephone call after we filed the motion for ineffective assistance of counsel, myself, DC counsel Aaron Panner were on a telephone conference with Attorney Carney and Attorney Zagangori, and Attorney Carney said in that telephone conference I had been in charge of jury instructions. And that was the first I'd ever heard anything like that.
Did he say that you had been in charge of anything else?
He said I was in charge of jury selection, advising Attorney Carney on local rules and practice, and jury instructions.
Had you before that point discussed that you would be in charge of jury selection, advising of local customs and rules, and jury instructions?
There had never been any discussion about jury selection. We had discussed, and I think Attorney Carney had represented to Your Honor, that he would call me if he had questions about local rules or customs during the trial, so that was discussed. And it had never been discussed that I was in charge of jury instructions ever.
And to be clear, this conversation took place after the verdict and after sentencing?
This conversation took place after the motion for ineffective assistance of counsel had been filed.
Judge, may I approach the witness, please?
Yes.
Exhibit 20. Did I move to strike the ID on the last one?
Attorney Rancourt, I'm showing you a document that has been marked for ID as witness, I'm sorry, as exhibit 28.
Okay.
You take a look at that and let me know if you recognize it.
Yes, I do.
Can you tell me what it is?
This is a letter I wrote to Attorney Carney on April 8th, 2016.
What was the purpose in writing that letter?
This was a letter following up on that telephone conference with Attorney Panner, Attorney Zagangori, Attorney Carney, and I. So, the end of the call with Attorney Carney, he said, "I want you to respond to what I said." And I said, "I'm not responding to you. If my co-counsel, Attorney Panner, because Attorney Panner is my co-counsel on the appeal, I said, if Attorney Panner has questions, I'm happy to answer them, but not with you." And we hung up the phone, and I wrote this letter to Attorney Carney.
Why?
Because I was shocked at what he said to me in that telephone conference. We absolutely had never discussed the things he was now claiming I was in charge of. I would not have agreed to do it if he had asked me to, given that I had not been present at trial. And I thought that that had to be documented, because after he said that, it became apparent to me that that's what he was going to, that was the story he was going to put forth, and it was not accurate. And I wrote this letter on April 8th documenting my file for him. I went through my billing records, I went through my email correspondence with their office, and every notation of every time we spoke throughout this case, and put it in this letter.
Why did you feel the need to document it?
Because it was very troubling for me that someone would say I was in charge of something that I had not been in charge of. And, you know, I would not have been effective to be in charge of, especially jury instructions. And I wanted that documented.
Is that letter an accurate statement? And is that in fact the letter that you wrote after that conversation?
It is.
Judge, I would ask that the ID be stricken on that, as well as the last exhibit, which I apparently again failed to move to strike the ID from, and that they be entered as follows. Thank you. Noting a pattern, Judge, I apologize. So you come out of the Chambers conference after jury instructions. Did you know the theory of the case?
I mean, from listening to opening and closings.
Did you feel as if the jury instructions at that point were appropriate and significant?
Well, at that point, when I did my review of jury instructions, nothing stuck out at me. I mean, again, I had not been through trial, so there was nothing that I thought this is a real problem in jury instructions at that time. Only looking back at some of the issues that I felt were not raised, were not litigated, did I start to think I would have asked for, looking back on what I think should have been litigated pre-trial, and depending on the outcome of those rulings, I certainly think the instruction should have been different.
So you were not apprised pre-trial of the theory of the case?
No,
You had not been present for the entire trial?
no,
You had not reviewed pre-trial motions or orders on those motions?
that's correct,
You had not heard all of the testimony in that trial?
correct.
No specific issues have been brought to your attention.
No, during trial, other than the issue that Owen and I addressed, they asked me a question on whether or not the motion for directed verdict should be written. And I think that was the only question they had for me during trial.
Had you been privy to all of that information, basically how the trial had gone? Would you have advocated differently for instructions?
Knowing what I know now, as far as what the discovery was and the status of discovery, and yes, but again, my position on jury instructions is that there should have been litigation pretrial, and that litigation pretrial would have driven certain instructions or not driven certain instructions. But I think it all goes hand in hand. So that's some of it. But I do think that at the time of jury instructions, knowing the status of the evidence, I would have looked at that computer charge differently, and at the very least advocated for some further definition of what lure or entice means in the nature of this case, with two people who are known to each other and go to school together and had taken photos together prior to that time. I would have advocated for some varying instruction just based on the status of the evidence on that computer charge.
Do you think it was clear for the jury what they needed to be unanimous on?
No, but that leads into the argument of the bill of particulars that I raised in the ineffective assistance to counsel motion too. I think that the problem with the computer charge is that the computer charge alleged that Mr. Labrie had lured, solicited, enticed Ms. Prout through email / Facebook. So the charge allowed an option for the jury. And so what I had said was, what I had written in the motion for ineffective assistance to counsel, which is how I look back at this now, is I think there should have been a bill of particulars breaking those two apart. That it's either the email or it's the Facebook. It's not one or the other, and you get to choose, which lends itself to a problem with jury instructions, because what if 6 of the jurors thought it was the email and 6 of the jurors thought it was the Facebook exchange? Well, then they're not unanimous. Really, they're not unanimous. And so there should have been some clarification at some point, whether it's pretrial litigation in a bill of particulars or in the jury instruction, that they have to be unanimous in what they find, and you can't kind of pick and choose this either or option that appeared in the charge. And that was a problem as well.
And speaking of the bill of particulars, would that also have played into the inter versus intranet piece?
Yes.
Can you explain how?
Well, if you had asked for a bill of particulars and it broke apart, my opinion would be that what you would ask the court to order the state to do would be to say, what is the communication that you think violates this statute? Is it the first email that he sends, the quote-unquote senior salute email? Is that the violation? Or is it the later Facebook communications, which were just setting up the location of where they were going to meet? Because if it's just the email was likely sent intranet, whereas Facebook, we know, would travel in the internet, and that would be an online service. So lumping them together causes a lot of confusion in that charge. And breaking them apart makes it clearer that it's either the email, which is intranet, and whether or not intranet would qualify, or it's Facebook. And then the jury could decide, well, are the Facebook messages enticing, luring, soliciting, if they're just arranging to meet somewhere where they had already arranged, where she had already agreed to meet him? So I think not breaking them apart lent itself to a lot of confusion.
Did you discuss, or would you have broached a nullification instruction?
I would have asked for one. Whether or not I would have gotten one, I don't know. But I would have asked for one.
On what basis?
I had always said, and I raised this with Attorney Carney, this was one of the issues that I had raised with them, was if the jury thinks, this is my opinion, if the jury at the end of the day thinks this was not forcible, these were two, I call them kids, but I know he was an adult, so these were two students who engaged in what would otherwise be consensual intercourse except for her age. If that's what they're thinking at the end of the day, the jury could think, under these circumstances, we don't think it would be appropriate to tag this young man with a criminal conviction, and they could find him not guilty, which is either through a jury nullification instruction or through just the standard reasonable doubt instruction, gives you an opening to at least argue that to the jury.
Were you effective in advocating jury instructions?
No?
I want to talk briefly about motions work, pretrial motions work. Do you have any discussions with Attorney Carney about motions that would routinely be filed in sexual assault cases in New Hampshire?
Some, yes.
Can you tell me what conversation that was?
Well, I think, so I had suggested to him to file the pretrial motion, which they did, that Ms. Prout should not be referred to as a victim during the course of trial. I spoke with them about filing a pretrial motion for mental health records, which is sometimes typical in a sexual assault case, but not always.
Do you remember when you sent those emails, or generally when those conversations happened?
The conversation about counseling records, I remember, occurred at the beginning of June in a telephone conference between myself, Attorney Fullerton, and Attorney Zagangori.
And what specifically was that conversation?
In discovery material, there were references to mental health counseling. There had been references to medications. There had been references to a prior suicide attempt, I believe, and a few other things. So that lent me to then reach out to Attorney Fullerton and Attorney Zagangori in that conversation about pretrial litigation to say, you know, there's something there. Obviously, there's some mental health history. I would file a motion for the minimum and in-camera review of mental health records and explain to them how that process typically occurs in New Hampshire.
Did they follow up with you about that?
No. No, they didn't, because I sent another email at some point later in the summer saying, I haven't seen anything be filed regarding mental health records.
What is the typical process in court for requesting mental health records of a victim or a witness?
Well, you would file a Gagney, I call it a Gagney motion, but essentially a motion for in-camera review. You have to provide some basis for why you think there is mental health records out there and why you think they might be relevant to your defense. And if the judge agrees with you, the judge can order, typically the way it happens is a judge can order an in-camera review of those records, and then the judge would determine if any records are relevant and provide those records to you. In this case, they were also wondering, in this conversation with them about mental health records, I think it was maybe Attorney Zagangori had raised the issue of it's possible that Ms. Prout had waived her privilege already because some of the records had been provided to the police, if I remember. There was some conversation about that, about, well, what maybe the privilege was already waived, so we didn't need to go through that step. And I said, well, either way, you got to file the motion either way.
Ultimately, Attorney Carney filed some version of a Gagney motion. Are you aware of that?
Yeah, I think they filed it with their motions in limine, if I remember.
Is that typically an in limine motion?
I would typically do it much earlier, because if there's something in those records that needs further exploring or further investigation, if you get it a few days before trial, you're not going to be able to do that.
Are you aware of what the court's order was on that motion?
They did get some records, so I think the court must have granted it, because my understanding after the fact was that they had received those records. I had not seen them, but that the defense had been provided some records at some point.
Are you aware of whether the defense did anything with the records they received?
I am, and they did not.
They did not.
No.
Are you aware of if they got everything that they requested?
It appeared as if they did not. The motion, when I looked back and I looked at their motion, it looked like they were looking for like the mental health history as far as from the counseling center at the St. Paul's School, and some more detailed information. I would expect some more detailed information about the attempted suicide and some other things that had happened long before. Later I learned, once I became counsel, during the appeal process, I was ultimately provided a copy of the mental health records that they did get. And I think they got like 12 pages or something. They were the mental health records that appeared to only pertain to the reporting of this allegation, if I remember correctly. They might have been a little bit more broad than that, but I think there was 12 pages.
Was there any indication in the discovery, anywhere in the file, of broader or additional mental health records that went beyond the scope of this immediate incident?
There's the notations in the discovery certainly would have indicated it. There was, I mean, I don't mean to keep saying it, but there was this reference to an attempted suicide earlier in that fall. Ms. Prout had reported to law enforcement in her interviews with her. She had said something like, I didn't want to alarm my family because I'm an alcoholic and I have a history of alcoholism or something like that. So there were some references that made me think there was something more out there.
You're aware that post-verdict, Attorney Carney and Attorney Zagangori filed a motion to set aside verdict.
Yes?
Were you aware of their intention to file that motion?
Yes.
And when did you become aware?
So after verdict, I think there may have been a conversation about if we want to file something about that charge, what's our time frame, it's kind of a general conversation outside the courtroom after the verdict.
Were you asked to do any work on that?
No, I was actually instructed not to.
I'm sorry, you were instructed to not do any work on it?
Yes. But I did.
But you did?
Yes.
Judge, can I have just 1 second, please?
Yes.
Thank you.
It's a good time to take a mid-afternoon recess.
Sure. Thank you. Thank you. You need more water? He doesn't need to come tomorrow.
They will.
So if we can approach the judge about that, I think that we have enough to fill at least. We started at 9.
Well, why don't, I have to go run downstairs and put another fire out. And so, but why don't, what I would suggest is, like, when the judge comes back, approach, and I'll just shout at him on my way down the stairs that you guys want to talk a little bit of scheduling when he comes back out. And then I told him tomorrow that he could start at 9 or 10, depending on you guys. So.
sort of like
Yeah, so if you can ask them again.
identify
I
my
will.
different body experience.
Oh, all right, thank you. Thank you very much. See, they have you come over and with the balloon. You're the balloon. Oh, there were, yeah.